Brazil's approach to data protection has significantly evolved with the enactment of the General Data Protection Law, LGPD, Lei Geral de Proteção de Dados, which came into effect on September 18, 2020. This comprehensive legislation was established to align with global data protection standards, particularly mirroring the European Union's General Data Protection Regulation, GDPR. The LGPD is a landmark in Brazilian law, setting out detailed requirements for the processing of personal data and enhancing individuals' rights. Overview of the LGPD. The LGPD applies to any processing of personal data carried out in Brazil, the processing of data of individuals located in Brazil, or the processing of data collected in Brazil, regardless of the nationality or location of the data processor. It introduces several key principles, such as purpose limitation, necessity, transparency, and accountability, which guide the lawful processing of personal data. The law defines personal data broadly to include any information related to an identified or identifiable natural person. Moreover, it places particular emphasis on sensitive personal data, including data related to racial or ethnic origin, religious belief, political opinion, health, and biometric data, providing it with additional protections. Rights of data subjects. Under the LGPD, data subjects are granted extensive rights, including the right to access, correct, delete, or anonymize their data, as well as the right to be informed about the processing of their data. Data subjects also have the right to withdraw consent at any time and the right to data portability. Data controllers and processors. Entities that process personal data must adhere to the LGPD's requirements, including appointing a data protection officer, DPO, maintaining records of data processing activities, and reporting data breaches. The law mandates data processors and controllers to establish measures to ensure the security of personal data and to mitigate risks associated with data processing. Enforcement and penalties. The National Data Protection Authority, ANPD, is responsible for overseeing compliance with the LGPD, including the enforcement of sanctions for violations. Sanctions can include fines of up to 2% of a company's revenue in Brazil, limited to 50 million Brazilian reals per infraction, as well as warnings, public disclosure of the violation, and the blocking or deletion of personal data related to the infraction. Notification of data breaches. A significant obligation under the LGPD is the requirement to notify the ANPD and the data subject in the case of a data breach that may cause significant harm to data subjects. This must be done in a reasonable time frame, as specified by the ANPD, providing detailed information about the nature of the breached data, the categories and number of affected data subjects, and the measures taken to mitigate the breach's effects. Historical context and global alignment. The LGPD's inception was significantly influenced by the global push for stronger personal data protection, most notably mirrored after the European Union's General Data Protection Regulation, GDPR. Before the LGPD, Brazil lacked a comprehensive data protection regulation. The legal landscape consisted of various sector-specific laws and regulations that provided piecemeal data protection. The introduction of the LGPD marked a transformative shift towards unifying data protection under a singular, comprehensive framework, aiming to facilitate Brazil's participation in the global digital economy by ensuring a high standard of personal data protection that aligns with international norms. Scope and application. The LGPD's broad application criteria mean that a wide range of entities, including businesses outside Brazil, may fall under its jurisdiction if they process the data of individuals located in Brazil. This extraterritorial reach necessitates that international businesses evaluate their data processing activities in light of the LGPD's requirements, similar to the GDPR's impact on global data practices. The law's scope extends beyond digital data to include any form of personal data processing, highlighting the universal need for data protection measures across all platforms and mediums. Detailed provisions for data processing. One of the LGPD's core principles is the establishment of clear conditions under which data processing is lawful. Consent is a significant basis for lawful processing, requiring clear, informed, and unequivocal consent from data subjects. However, the LGPD also allows for data processing on other legitimate grounds, such as contract performance, legal obligation, health protection, and legitimate interests, among others. This flexibility is crucial for organizations to navigate the complex landscape of data processing while ensuring the protection of data subjects' rights. The role of the ANPD. The creation of the National Data Protection Authority, ANPD, as the regulatory body overseeing the LGPD's enforcement is a pivotal aspect of the law. The ANPD is tasked with issuing guidelines, advising the government on data protection policies, and acting as a national point of contact for data protection matters. Its role extends to promoting data protection culture and best practices among organizations and the general public. The AN's interpretative guidance and regulatory actions are instrumental in shaping the practical application of the LGPD. Challenges and considerations for implementation. Implementing the LGPD poses challenges, particularly for small to medium-sized enterprises, SMEs, that may lack the resources for comprehensive data protection programs. The requirement to appoint a data protection officer, DPO, for instance, underscores the need for internal expertise on data protection matters. Furthermore, the LGPD's emphasis on data subjects' rights necessitates robust mechanisms for handling individuals' requests regarding their data, which can be resource-intensive. Comparison with global data protection laws. Comparing the LGPD with other data protection laws, such as the GDPR, reveals both similarities and unique provisions that reflect Brazil's approach to privacy. While the LGPD shares the GDPR's general structure and key principles, it also incorporates distinct elements, such as a more detailed categorization of sensitive personal data and specific provisions for the public sector. This comparative analysis highlights the global trend towards enhancing data protection while accounting for local nuances. Future directions. As digital technologies continue to evolve, the LGPD will likely face amendments and updates to address emerging privacy challenges. The dynamic nature of digital data processing requires ongoing vigilance and adaptation from both regulators and the entities subject to the law. Looking ahead, the interaction between the LGPD and international data transfer mechanisms will be a critical area of focus, particularly in facilitating cross-border data flows while ensuring the protection of personal data. Conclusion. The LGPD represents a significant milestone in Brazil's data protection landscape, providing a comprehensive framework for the protection of personal data. Its enactment aligns Brazil with global data protection standards, fostering trust in the digital economy and safeguarding individuals' privacy rights. As businesses and organizations navigate the LGPD's requirements, the law not only enhances data protection practices but also promotes a culture of privacy that is essential in the information age.